Good afternoon, and thank you everyone for attending today's webinar, Medical Marijuana in the Workplace, presented by Sheila Mintz of Capehart Scatcherd. Please be aware that there will be a question-and-answer portion today at the end of the webinar. To avoid frequent interruptions during the webinar, please type your questions in the question box located to the right of your screen. They will be answered in the order received during the question-and-answer portion. Additionally, an electronic version of this presentation will be emailed to all participants following completion of today's webinar, and a recorded version will be available on the website for members only. Again, NJMGMA would like to thank you for attending, and I'll now turn things over to Sheila.
Good afternoon, everyone. Thanks for attending. I'm going to be talking about medical marijuana, to some extent just what's going on in the law right now, and what do you do about it in the workplace when you have employees that are using medical marijuana. So I guess first off, medical marijuana was legalized in New Jersey in 2011, and not an awful lot of changed in between 2011 and 2018, but since 2018 and the new governor, Governor Murphy, there's been a lot of talk, and there's been a lot of proposals for expansion. The 2011 law basically created the 6 existing dispensaries, although one of them I think is not actually functioning. So there are really 5 functioning dispensaries throughout the state and 544 doctors that are authorized to prescribe, or register their patients for use of medical marijuana. Basically what happens is right now most of the dispensaries are in South Jersey. They're Vineland, Belmar, I think Egg Harbor. There's one in Montclair, and I think there's one projected to start in South Jersey. So basically it's concentrated in the South. As you can imagine, that might create a little bit of a transport issue if someone lives in Central or North Jersey and has to go to South Jersey or someplace far out of their location to be able to obtain their medical marijuana. And particularly in view of the existing restrictions on the amount that people can obtain, I think it's less than 2 ounces to be able to go forward. Then that means that there has to be some more frequent trips to the dispensary, which can be hard on someone who's disabled. So Governor Murphy has stated an extension to expand medical marijuana in New Jersey, and there's a proposal in the works, I gather, to increase the number of dispensaries, to triple the number of dispensaries in the state. So basically adding another 18 dispensaries all over the state of New Jersey, and which would also at this point include a grow license. So the dispensary, or what they call the alternative care centers, would be tied also into a license to grow marijuana in a licensed grow area, which I think, probably not all dispensaries want to do that, but that's the way the licensing is going to be working. That's the way it's worked up until now, and that's the projection going forward, is that there would be a grow license along with the alternative care dispensary license. So basically what happens if a physician wants to prescribe, I'll get into that a little bit, but basically right now there are 544 doctors that are authorized to prescribe, and I guess prescribe is probably the wrong word. It's really just registering their patient, because they don't make an actual prescription the way we would understand that, in terms of saying, okay, so many pills per day, or so many, twice a day, or such and such a dosage. That's really left to the dispensary. Essentially, the physician is registering the patient for the ability to obtain medical marijuana, and there are only 544 doctors who are authorized to do that. Mostly they are family family doctors, family practice doctors, internal medicine. It looks like neurology is a little bit, oncology, I think, obviously, and psychiatry are the main focus of the doctors that have ability to prescribe. So basically, the pending legislation is designed to allow any doctor with a DEA license to prescribe medical marijuana to their patient, as long as the patient meets the requirements of the law. So let's see. The current act allows the use of medical marijuana in certain debilitating medical conditions. There at the beginning, it was basically just different types of seizure disorders, some ALS or Lou Gehrig's disease, epilepsy, other types of muscular dystrophy, inflammatory bowel, glaucoma. Post-traumatic stress disorder has been added in since the 2011 act, along with a couple of other conditions, and there may be other conditions going forward that will be helpful. One of the problems, I guess, in testing the use of medical marijuana is that since it's a Class A drug or Class 1 drug, Class A, under federal law, it's not allowed to be used in clinical trials and things like that. So unfortunately, there's sort of a minimal amount of use that it's been deemed to be appropriate for, and because of that, there's only a few conditions that are allowed in New Jersey, and in most states it's sort of very similar to the other states related to medical use. So this is the condition. This is the current law. And those are the disabilities that are allowed use for medical marijuana. The patient who is, obviously the physician who's prescribing medical marijuana needs to be certified by the Department of Health, and that requires a certification. It's on the website. They have to have obviously an existing good standing medical license in the state of New Jersey. They have to have CDS and DEA registration which can't be restricted in any way. The Department of Health does a background investigation, so if there's ever been any issues related to billing fraud or overprescribing of opioids or any of those types of things with this particular physician, I would anticipate that they would not be issued a certification to prescribe. The patient who wants to receive medical marijuana first needs to be registered by the physician, and the physician has to certify. Well, I'll get into that later, but the patient has to register, has to upload a photograph, has to have a background check, has to be fingerprinted to make sure that they don't have any previous drug convictions or arrests or any addiction issues that the state needs to know about. Generally, they must carry a card showing that they're certified to obtain medical marijuana, and that's how they get it, by going to the dispensary, and at that point it's dispensed to them. If you can imagine people who have current diseases like ALS or HIV or muscular dystrophy or terminal cancer, other types of terminal illnesses, it might be difficult for them to drive an hour or 2 hours throughout the state to be able to obtain their correct dose of marijuana. So what the state has allowed is a patient caregiver who can obtain the marijuana on their behalf. Now, that patient caregiver essentially has to go through the same registration process as the patient does. So they have to register, have a photo, have a background check, be fingerprinted, and get a card showing that they are a registered caregiver of the patient. And then they can go to obtain the medical marijuana at the dispensary on behalf of their family member or their close friend or whoever the person that they're registered as a caregiver for. The patient cannot transport. You have to be very careful not to transport medical marijuana across state lines. The medical marijuana and marijuana in general is not is illegal under federal law. So there's a real conflict of laws going forward. So crossing the border from New Jersey to New York with medical marijuana, or from New Jersey to Pennsylvania, would be a violation of federal law. So even though you are allowed to transport medical marijuana, assuming that you have the proper registration card as a patient or a caregiver, you have to be very careful not to drive across state line. So sometimes I live in South Jersey, so I drive from South Jersey to North Jersey, and by doing that, I drive occasionally through Pennsylvania because that, depending on where I'm going, that may be a better way for me to go. But you have to be very careful not to do that if you're transporting their medical marijuana. The patient can also have what the law calls paraphernalia allowed, that they need for smoking marijuana, which would be a vape pen or a bong. I'm not quite sure how else people use it these days, but so they are allowed to have the paraphernalia as long as they have their medical marijuana card with them and can explain what the usage is in case they get stopped by the police when they're driving from place to place. But the patient has to remember that they can't just, even though the fact that they're allowed to obtain and to use medical marijuana does not mean that they can smoke it wherever they want to. So that's something to be very careful about. If smoking is not allowed in a certain area, like in a restaurant or a bar or in a park or any of those things, if the smoking is not allowed, smoking marijuana is also not allowed. There are additional regulations in terms of smoking or not being able to smoke within a certain distance of a school. Generally, I would say the best rule would be to smoke it at home if you're going to smoke it. Now that there are the new pending legislation allows, talks about more in terms of different types of edibles, which may resolve the issue in terms of where someone is allowed to smoke. If they can obtain the medical marijuana via an edible, whether that be a tablet or a gummy bear or a brownie, they can carry that with them and just consume it, and then it doesn't obviously cause the same problem as smoking marijuana. So as I said, the physician prescribing needs to register. There are 544 providers at this point out of the 28,000 doctors in the state of New Jersey. And again, most of them are primary care, oncology, pain/anesthesia, psychiatrists and neurologists, because obviously the conditions that are allowed to be prescribed for are within those specialties. I know a lot of my clients, because I'm a healthcare attorney. A lot of my clients prescribe or register their patients for medical marijuana, and they're concerned about their medical license as a result of this activity. But there is a provision in the Act which completely exempts patients and physicians from criminal prosecution or civil penalty as a result of the lawful prescribing or use of medical marijuana. So the fact that a physician, and I know many of you are medical practice managers, if you have a doctor in your practice that prescribes medical marijuana, they don't need to be concerned about a licensing, a board referral, if they're prescribing within the context of the law. in reading about what's going on right now in California, I was kind of surprised, but there was a doctor who calls himself Kush Doctor, which I guess is what some people call marijuana these days, and essentially rides his skateboard up and down the boardwalk in Venice, California, asking people if they're interested in a prescription for marijuana and directing them to his medical office. That, I think, in New Jersey would not be the qualified way to prescribe medical marijuana. So as long as the physician is not doing that and is complying with the registration laws and the way that they're prescribing, then that would be, there is no civil or criminal penalty. The physician obviously doesn't dispense in their office. I don't see anything in the new pending legislation that would change that to allow physicians to dispense. So realistically, that's not going to be an issue, at least at this point. So the New Jersey law on discrimination, and this is really where I get into the workplace issues. The LAD prohibits discrimination against people with disability. So disability is essentially a physical, non-physical, mental, psychological, developmental disability, which prevents the normal function of people in the workplace or in other situations, but we're concerned with the workplace. So how does it work in the workplace if you have a worker that is taking medical marijuana? So right now, the New Jersey Act provides that the physician does not have to accommodate the use of medical marijuana. But most of the people, as you can see from the previous slides, most of the people or all of the people who are using medical marijuana have some kind of underlying disability. If that's, that may be cancer, it may be psychological, post-traumatic stress disorder, it may be muscular or, epilepsy, muscular dystrophy, ALS. All of those are underlying disabilities, while the accommodation for the use of marijuana itself is not required the employer is not required to do that. The employer would likely be required to accommodate for the underlying disability, which requires the medical marijuana use. So you have to be careful in this because there's a little bit of a divergence, and people are saying, oh, well, I don't have to accommodate that person for using medical marijuana, but you may have to accommodate their underlying disability. So the question is, how do you know? The cases that have gone forward right now are related to most of the employers don't initially know if the employee is using medical marijuana, and it's only come out in the context of a workplace incident. So basically, as I said, the Act is exempting employers from having to accommodate the medical use of marijuana. And I guess what does that mean exactly? So I would take that to mean that you don't have to provide them with a time to go out and smoke marijuana outside or in their car or anything like that, that you don't have to give them that ability to do. However, again, we do have to accommodate the underlying disability if that requires an accommodation. If someone is, has cancer and they need to have time off to go for chemotherapy, you have to accommodate that. If they have physical restrictions as a result of whatever condition they have, that may be something that you'll also have to accommodate. The law right now is progressing as medical marijuana becomes more prevalent within the United States. Several states, Massachusetts, Rhode Island, Arizona, Colorado, have required reasonable accommodation of medical marijuana use in terms of being able to go outside and smoke during the day or something along those lines. Again, I think as different types of medical marijuana are available, then there's going to be less and less of an issue in terms of being able to go out of the office to smoke or something like that. It wouldn't be dissimilar for, an employee who was breastfeeding to be accommodated for time to go and pump or something along those lines. So I think that's sort of what they're talking about in a lot of the states where they've required the reasonable accommodation. But again, I think as there are more edible and tablet forms of taking medical marijuana, then that this issue in terms of giving people time off to go and do what they need to do is going to change. There are several bills in the legislature which may affect the New Jersey employers' obligation to accommodate in the future. But again, I think there's some confusion between accommodating the underlying disability and also and accommodating the use and the time off to go and use marijuana if that's necessary. So accommodation after hours. So you may need to change work schedules. You may need to adjust job responsibilities. Obviously, if you have an employee who is required to go to chemotherapy, then you might give them time off to do that. You might have to, if there are times when they have to go to a dispensary to pick up medical marijuana, you might allow them to do that also. But that's not a required accommodation in terms of having to go and pick up medical marijuana. So the main thing I think that concerns me, I think, is safety in the workplace, because there really isn't a test in terms of saying if someone's impaired by the use of medical marijuana. Right now, they're working on a lot of different strains that relate to medical marijuana, where they'll take the THC or lower the THC so that people can use it during the daytime, and it's not going to affect their ability to drive or to operate equipment or to do other things in the workplace that might require, that might be safety issues. So, so they're basically, if you're under the influence, you're not supposed to drive. It's not dissimilar to being under the influence of alcohol or another type of drug while you're driving or performing, lifting things with a pitchfork or one of those forklift things or something along those lines that require or flying a plane, for example. Those are things that very rarely happen in medical practices, but driving is not unheard of. Certainly, going from place to place, going from office to office, doing house calls or other types of things, going to nursing homes, that would be part of the patient requirements and the employee requirements for their job duties. So the question is, I guess, what is under the influence? And nobody really, I would say, knows what the answer to that is yet. The drug tests will show that the person has used marijuana at some point. You can do a hair test, you can do a nail test. It will show the presence of marijuana in the system for, I think it could be up to a month or 2 months. But generally, there is not a current drug test which shows that someone is impaired. If someone has smoked marijuana, I guess you could design a breathalyzer test that would be able to read that. But as people go into more of the edible and maybe tablet or oil forms of medical marijuana, I think the breathalyzer is likely to be is likely to be not really dispositive of whether someone is under the influence. Obviously, if someone is sort of wandering around and staring at the ceiling, I mean, it's the same thing if somebody comes to work drunk or on other drugs. You can tell that they're not they're not acting normally, then, that certainly would lead you to believe that they were under the influence. But it really is hard to make that determination in terms of degree of impairment with medical. to furnish a place of employment that is reasonably safe and healthful. Everyone knows about OSHA. Everyone knows about the Occupational Health and Safety Act, which is OSHA, and then there are any number of regulatory agencies that regulate the safety and management of the workplace for physicians and ambulatory surgical centers, hospitals, and all of those things. So the medical advances, again, may produce different types of strains that will reduce THC, so the actual amount of the influence will not be as much of an issue, and I would anticipate that someone's going to figure out how to create a test that will provide that someone will be able to tell whether someone is actually under the influence and is affected from a psychoactive point of view by the THC in the marijuana. So all of these things are going to be happening, but right now we're kind of in the Wild West when it comes to the use of medical marijuana in the workplace. So there's a couple of cases right now. I mean, again, this has only been legal in New Jersey for a few years, so everything takes a while to get through the court system. So right now there's kind of an interesting case which I think highlights what I was talking about in terms of the requirement to provide an accommodation for underlying disability, and then also not discriminating against the patient. So the plaintiff in this case was a funeral director who was using medical marijuana in the evening as treatment for chemotherapy, relief of nausea, and general cancer treatment. He was driving car and got into an accident, which, if you read the entire case, was evidently not his fault. When he was in the ER, he disclosed his marijuana use as part of the intake process in the medical history to the treating physician. The ER doctor did not test for drugs because the marijuana test would not show a degree of impairment. But then when the employer found out about it, the employer went sort of ballistic. I gather that in the ER, the plaintiff had received some pain drugs, and he had been injured, and he received some opioids like Percocet or Vicodin that would show up on a drug test. So obviously, as soon as the employer required the drug test, which was after he'd been released from the ER and released from the hospital, the test was positive. He was terminated from employment. And then at that point, the employer staff allegedly disclosed to potential employers and to the Funeral Directors Association that the plaintiff had been fired for being a drug addict. I would say this is probably, if we don't, obviously this hasn't been decided, this is still in the appeal process, but I would say this is sort of a poster child. This case is a poster child for things not to do when you discover that an employee is using medical marijuana. I think if you have to really look at someone to see if they are in fact impaired by the use, if the accident was not indeed his fault, if it seemed like reading the case that the plaintiff was rear-ended, so it probably wasn't his fault, but there wasn't any real allegation of impairment. It was just a positive drug test. And then after the termination from employment, there was the issue of, we don't know from the case what the required accommodation was, if any, for his cancer treatment, but clearly disclosing to a potential employer and to the entire Funeral Director Association that the person had been fired for being a drug addict is a little bit different than saying that the person was fired for having a positive drug test and the knowledge that they were using medical marijuana. I don't think you would ever want to really disclose the drug test as an employer, because I can see all kinds of liability that might come out from that. So I would say this is probably the thing that you would not want to do if you discover that an employee is using medical marijuana via a workplace accident. A similar type of case is going through the courts. This Cobb v. Glass, I gather that the patient was operating some machinery at the workplace, and there was an accident, and the test revealed that he was using medical marijuana. There was, again, no indication that he was affected. There was no allegation that he was not paying attention, not able to conduct his job, just that there was a workplace accident that might or might not happen regardless of a person's, there was no showing of intoxication, basically. The employer did then find that the plaintiff had violated their drug policy, and that they could let him go because there was no requirement of the accommodation for the use of medical marijuana. Well, I mean, the question, I guess, right now before the court is not what whether they were required to accommodate the use of medical marijuana, but whether they were required to accommodate the underlying disability. So that really is the issue here. His physical condition, the reason for the prescription of medical marijuana, is really not set forth in this particular case because it's in appeal, and the case isn't really that descriptive of what the reasoning was for it. But the question now that the court is going to be looking at is whether the underlying disability requires an accommodation, and therefore should they have not fired him. One of the big issues, I think, for medical practices, which both not so much prescribe, but if you have a worker, an employee, whether that be a physician, a PA, a nurse, a medical assistant, a receptionist, of what what that would cause for the practice. And then for the physician side, you need to look at what the requirements are in terms of being able to prescribe or to register a patient for medical marijuana. So obviously, as I said before, the physician has to have an active license and CVS credentials. The physician has to have a bona fide relationship with the patient. So you can't just skateboard down down the boardwalk in Atlantic City and start recruiting patients saying, we're the new doctor in town, and come over to our office and we'll give you a prescription. There has to be some kind of ongoing relationship. So if the physician has been seeing the patient for at least 1 year, that would likely work. Then, if they've seen the patient for this debilitating condition at least 4 times. So someone has to come in and not just say that they have PTSD and they write a prescription. It has to be an ongoing level of treatment, or they've taken over the continuing care of the patient after a detailed review of the medical records and discussion with the previous physician and all of those things. So again, the physician cannot dispense marijuana. So if you have an oncology practice where there is a practice where there is a pharmacy within the practice, that is not allowed. You can't dispense marijuana there. The patient can only go to an alternative treatment center, and then the physician has to register the patient. So I guess in terms of what you would do in a medical practice, all right, to stay. So first of all, you need to, along with all of the other policies that you have for your employees, you really need to look and finalize at your drug policy. If you don't have one, you need to have one. You need to communicate that policy to your employees. If an employee comes to you and advises that they have a disability and that they are using medical marijuana, I think it's really going to be on a case-by-case basis as to whether you can accommodate or whether you need to restrict their activities. If you have an employee that is using medical marijuana and has a disability, then before you terminate or discipline that employee, certainly suggest that you consult your attorney to make sure that you're doing it in the absolutely correct way, and that you're not doing something like happened with that in that funeral director case, where you go out and tell everybody that so and so is fired for being a drug addict. I can see that would create a massive amount of liability for the practice, and and really not. It's something that you generally don't want to do as an employer. Generally, if you let an employee go for whatever reason, the best practices are usually, if you get a request from a future employer for a reference, is to confirm that the employee worked there and give the dates of employment, and that's about it. I would very rarely, if ever, get into the reason for termination, because that can only come back to bite you. Certainly stay up to date. This is a rapidly changing environment related to medical marijuana, and you need to be really careful about accommodating the use of medical marijuana and accommodating the disability. So I think we're going to be doing periodic updates and blog posts to tell you what happens as things happen. But there's a lot of case law going on. As you can see, nothing's really been decided, but I would anticipate that there's going to be some change going forward. In making your own drug policy, I think you need to think about the workplace safety issues. I advise a lot of my clients on issues with impaired staff people. So I think it really depends on what your employee does in your workplace. Certainly you're going to be in a different situation if you have someone who is potentially disabled in some way, and taking medical marijuana, who is your receptionist or making appointments with patients. There's going to be a difference between that person and a person who may be assisting a doctor during a performance of a procedure, or being a doctor who's performing a procedure. You can imagine that the medical malpractice liability, I would think, is real bad potential. I mean, I've had questions from practices related to PAs that are known to have drinking problems, although they've never presented at work related to that as being intoxicated. They know that they have drinking problems, and they've had situations at office parties and things like that where the person has become obviously intoxicated, and there are other stories and things like that. So my concern has always been, what happens when there is a malpractice claim and they find out that the doctor, the PA, the nurse anesthetist, any of these people are on medical marijuana. I have to think that that's going to come in and create an additional issue with negligence, and we really don't know how that's going to be how we're going to respond to that. So I think when you're talking about a drug policy, you really need to look at whether the job can be performed with reasonable accommodation when that person is on medical marijuana, and what kind of duties do they have. If they have to move a fluoroscopy so that a pain doctor can do a fluoroscopy guided procedure, will that come in? If there's a problem with that procedure, will that come in as a malpractice claim? And I would have to think that it will, and that will become an issue going forward. So will medical marijuana use increase the liability of the employer? At this point, there's not a lot of law that says that it won't. So I have to think that it likely will. It's because there are no tests to show the influence, whether someone is under the influence, whether they are, high or, out of it, or, whatever, however you want to describe it, that they're under the effect of marijuana. It's the same thing as being under the effect of alcohol or other types of drugs. It would be a real risk to allow someone to perform that kind of really safety-related occupation. So again, it's going to be a case-by-case basis as to whether your workplace and whether the activities that the employee needs to perform can be done when they are using medical marijuana. Obviously, if somebody is physically affected and you have to make other accommodations in terms of someone who has, muscular dystrophy or other types of neurological or muscular conditions that require accommodations, yes, you would have to accommodate for that. But the fact that someone is possibly under the influence of marijuana in a medical practice, I can see that as creating a lot of liability, which there really isn't much of an answer for at this point. So that's just something that is going to be an issue going forward. And I think I would recommend to all of the medical practices to really talk to their attorneys and to really thoughtfully think over how they would want to handle any kind of an employee who's working in a capacity where there's patient contact or where there's procedures and things that are being provided to patients that may subject the practice to potential medical malpractice or negligence liability as a result of their medical marijuana use. So certainly, we'd be happy to take any questions related to that. And we can assist our practices with creating that kind of a policy. But I think it's something that's very, very important going forward because we don't have a lot of answers at this point. But all we can do is do the best that we can professionally to make sure that we're not adding fuel to the fire by relating information to the outside world, regarding someone's disability or medical marijuana use, and creating a drug policy that can be lived with on a day-to-day basis. So I think that's about all that I need to talk about related to this. If there are any questions, I'm happy to take them. So, Alex, if there's any questions, I can take them now. Alex?
Oh, sorry, I was on mute. If there's any questions,
that's okay.
If there's any questions, you can type them in the question box. We'll just give everyone a minute. And Sheila, if there's anything that you want to add.
Well, I think I've been over it pretty in depth. I mean, I think the answer to the answer is that we don't have all the answers yet, but that we have to be really cautious about having medical marijuana in the workplace and having a good drug policy for your employees, which is communicated effectively to the employee. And making sure that you're talking to your attorney about any issues that arise as they go forward. Certainly, there are a number of programs for impaired employees, whether that be the Employed Physicians Program at the state of New Jersey, or the RAMP program for nurses. I know PAs go to the impaired physicians program. So in lieu of letting somebody go, you might require that they go to a rehab program. But generally, with medical marijuana, it's it's kind of a tricky issue because they very likely have an ongoing chronic condition which may require ongoing use of medical marijuana. And if that's the only thing that works for them, particularly if someone's going through chemotherapy, you know that they have, it's sort of a short-term or shorter-term, treatment process than someone who has an ongoing chronic muscular degenerative disease or muscular dystrophy, which is really multiple sclerosis, which is an ongoing and years-long condition that may require ongoing treatment with medical marijuana for the benefit of the patient. However, if it looks like the patient is going to lose their job as a result of their medical marijuana use, they may be offered the option of going into some kind of rehab or discontinuing use to allow them to keep their position. I know that this is a number of years ago, I'd read a case about a surgeon who lost her license in California when a drug test showed that she had used marijuana. At this point, there was no allegation that it was medical marijuana, that she had just used it recreationally, but it showed up in her nails and her hair. And again, there was no allegation that she had performed surgery while she was under the influence or any of those things, but ended up losing her license because essentially it showed that she had used marijuana at some point. And that seems pretty manifestly unfair absent a showing of performing surgery under the influence. But again, the way the testing is now, it's very difficult to tell. So I think you have to be better safe than sorry in terms of physicians and people that are in the positions of extraordinary scrutiny on what their job duties are, and to be able to perform and not create issues of liability for themselves. So, that being said, I don't know that there's a lot of other. It doesn't seem to be any questions, but if there are any, certainly the presentation is going to go out to and be available to the participants and to other people, and my contact information is available. So feel free to call or email me with any questions that might arise as you talk about this with your employers and at your medical practice. And if you have any questions going forward, we'll be happy to advise.
Okay, so we have two questions that were submitted. The first is, if you have an employee who uses medical marijuana who works in a safety-sensitive area, can they still work for you?
Well, that's the kind of the question that's a big question. And what I was talking about, can they still work for you? The answer is possibly. Are they going to be in a situation where they are creating a medical malpractice or a liability hazard for the practice? So if you have a PA that assists with surgery, or a PA or a nurse that does anesthesia, or a physician that's performing a procedure who is using medical marijuana, I have to think that that's going to create some level of liability for the practice should there be a malpractice claim. So I would think that, a plaintiff's attorney is going to run to that and say, this person was under the influence of marijuana while they performed this procedure. So again, that would have to be on a case-by-case basis. You'd have to look to see whether the person shows any signs of being under the influence, of being not able to perform their job. then if there's any inattention or any of those things. But it's a very tricky question because you really don't know. And because there is no testing that's available to show a level of impairment like there is with alcohol, you can look at a blood test. You don't say that a physician or a PA or, someone in that type of situation is never allowed to take a drink of alcohol. Or, a pilot, you're never allowed to take a drink. You are allowed to take a drink, but you're not allowed to take a drink within a certain period of time of performing the activities that you need to perform, which are very require a great deal of focus. But there is no test to show that with medical marijuana. So it's not a yes or no question in terms of being able to say, yes, they can definitely work there. I think it has to be a case-by-case basis. And I would recommend if you have an employee that is using medical marijuana and they're in a safety, if they're in a position where they're creating a liability or there's going to be a safety issue or a liability issue, then I think you really need to talk to the employee. You need to talk to the employer. And I would really suggest talking to your attorney to make sure that you're not doing something which subjects you to a wrongful termination claim or, a demotion claim or something along those lines on behalf of the employee, and also would potentially subject you to a medical malpractice or a liability claim on behalf of a patient. So it really, you're navigating very, very tricky waters here, and there isn't a lot of case law, and there isn't a lot of answers at this point. So I'd say it really would be something to do on a case-by-case basis, consulting with the employer, with your attorney, and and with the patient in terms of, or with the employee to see what their function is, what their functioning is. And I guess that would be the answer to that question. I don't know if that's really an answer, but that's the answer that I have at this point. So, Alex, was there another question?
Yes. If your employee has chronic pain and mobility issues with that pain and they use medical marijuana, what does an employer have to do to accommodate the employee?
Well, you have to do. Remember, it's two different things. So you don't need to accommodate the use of medical marijuana. You don't have to give them a smoke break if that's what they're asking you for. But if they have underlying pain and and physical issues that mean that they can't sit for a long period or stand for a long period or move or whatever restrictions that they have, you should have to accommodate the underlying disability that causes the medical marijuana use. So you need to ask the employee for whatever restrictions her or his physician has indicated in terms of what they can do at the workplace related to their physical disability rather than to their use of medical marijuana.
Okay, and one more. If you are a medical review officer and you come across a drug screen that is positive for marijuana, you call the employee and that employee states they have a prescription for medical marijuana. Is that drug test now negative because they have a valid prescription, just like with the use of narcotics?
No. It's not a negative drug test. If they state that they are using medical marijuana, then they have to present you with the card that shows that they are a medical marijuana patient. So they should carry that with them at all times if they have it, and then you have to make an affirmative decision as to whether the use of medical marijuana is potentially going to affect their job performance and whether they're able to continue with the duties that they're required to do. And again, that's on a case-by-case basis. And I think something that you need to look at in your own workplace drug policies to make sure that you're encompassing that, because it's not you don't need to, if someone fails the drug test, you don't need to create a negative. It does not create a negative drug test. You can make a decision at that point whether you're going to accommodate or not accommodate, or assuming that they have an underlying disability, then whether you need to accommodate that. But it doesn't create a negative drug test, no.
We actually have two more that were submitted also. If your employee has chronic pain and, oh no, that
might have been the one from before.
Yeah. How is the use of medical marijuana different from those who use narcotics for pain?
Well, in terms of how that works from a physiological standpoint, I don't know. I'm not a doctor, but in terms of working in, the problem is that medical marijuana is a very new treatment, and the law on it is very new. It is illegal at the federal level. It is legal for medical marijuana in the state of New Jersey. So how is it different? I mean, it may not be different in the terms of how it works for people physiologically. I think certainly from what I've heard and what I've read, medical marijuana has a significant, improvement over a lot of the pain medications that are so addictive and so toxic and have created, the opioid crisis that we're all dealing with. So, as I understand it, medical marijuana is not nearly as addictive, or may not even be addictive, for use in medical treatment. So, to that extent, there's a benefit to it. But in terms of the actual use of it in the workplace, it's a new you're not going to fire them as long as they're not showing up to work, under the influence or unable to perform. And the question is, do you have to do that with marijuana? And, I would say at this point, it's not clear. You don't have to accommodate. Certainly there are cases going through the courts that show that there's at least some interest in creating an accommodation, but there has been nothing that has happened in New Jersey. I think the law is going to change probably over this year. Some of the pending legislation does require some accommodation, and I think that as testing improves in terms of being able to tell whether someone is actually impaired, that's going to make it more on the same par as someone who uses opioid or other pain medications for pain.
If you are terminated from a job because of medical marijuana, what things are in place to protect the employee who does use medical marijuana?
Not very much. It's not just for the use of medical marijuana. If someone is terminated, remember that right now medical marijuana is only prescribed for certain debilitating conditions. So presumably someone who is taking medical marijuana also has a disability which might qualify them for accommodation under the law on discrimination in the state of New Jersey. So if you're being fired strictly because you're using medical marijuana and for no other reason, then I would say that there are some things, again, floating around to the courts, some of the cases that I talked about, that would lead me to believe that there are going to be some safety measures, some measures put in place to protect a terminated employee. But right now, there is not a lot of stated protections. However, if someone has been terminated because they take marijuana for a stated disability which requires an accommodation, then you may have a wrongful termination type of action under the law on discrimination. But again, that's going to depend on the facts and circumstances of the particular case.
Okay, I think that was all of the questions we have for today. And Sheila's contact information will be on the presentation that we email out to all of you. So thank you for attending, and thank you, Sheila.
Thank you very much.